Ladies and gentlemen, welcome back to the Indie Zone. In an historic 6-3 decision on June 29th, 2026, the United States Supreme Court, in the case styled as Chatrie versus U.S., ruled that law enforcement's use of a geofence warrant was a search as contemplated by the Fourth Amendment, which will generally require, with some very specific few exceptions, law enforcement searches to be based on a warrant. We have on our YouTube channel's community page a link to SCOTUS website where you can listen to oral argument that was held in this case back on April 27th, 2026, along with a word-for-word transcript from oral argument on that day. What this has done is it has sent the conviction of a Virginia man who was convicted of a 2019 bank robbery that utilized this geofence warrant to help to locate him back down for the lower court to consider whether the Fourth Amendment was violated here, whether the search was reasonable or not. In the majority opinion, it stated that an individual has a reasonable expectation of privacy in records about his cell phone's location, and police intrude on that constitutionally protected interest when they demand the information, even though it's just for a limited time and from a third party tech company. Chatrie versus United States involves a man who was armed with a firearm entering a federal credit union outside of Richmond in Virginia and gave the bank teller a note which demanded money. He later made off with nearly $200,000. In attempting to locate him, law enforcement officials who did not have any leads served the technology company with a geofence warrant, which directed the tech company to provide LEO with location data for all cell phone users who were near the bank at the time of the robbery. And it took a couple of times going back to the tech company to narrow things down. The third time that they did, the detective asked for and received the names and information associated with 3 accounts, one of which was Chatrie's. And then, relying on the location data, law enforcement officials obtained a warrant to search 2 residences linked to Chatrie, where they found almost $100,000 of the stolen cash from the credit union, along with other items, a firearm and demand notes. And then Mr. Chatrie was charged with bank robbery. He asked the trial judge to bar prosecutors from using the evidence that they had obtained as a result of the geofence warrant at trial, asserting that the warrant violated the Fourth Amendment. And although the federal district court judge agreed that the warrant in this case did not have the type of probable cause and requisite specificity that the Fourth Amendment requires, the judge nonetheless allowed the prosecutors to use the evidence, reasoning even if there had been a violation of the Fourth Amendment, that it was not in bad faith, that law enforcement officials had acted in good faith. This thereafter caused Mr. Chatrie to plead guilty to bank robbery, although he did not sign away his right to appeal. He retained his right to appeal in the deal with the government, and then he received a sentence of nearly 12 years imprisonment, followed by 3 years of supervised release. This then set forth an appeal to the United States Appellate Court in the Fourth Circuit, and ultimately it made its way to the Supreme Court. So there we have the ruling regarding geofence warrants our searches. We're going to continue to monitor this case to see what happens after it goes down to the lower tribunal and report back to you in future. Until next time, this is Kathy. Thank you for joining us here today.